Hey, Patriots, it's time to uncover the truth. Today, I want to talk about something that should send chills down the spine of anyone who still believes in the Constitution. Governor Gavin Newsom just signed Assembly Bill 1344, a law that gives California's prosecutors the power to confiscate firearms under expanded red flag rules, all in the name of public safety. Now, I'm all for keeping communities safe, but when the government starts handing out the power to seize your property before you've even been charged with a crime, that's not safe. That's a constitutional disaster waiting to happen. This bill isn't just another line of fine print in Sacramento's endless war on gun owners. It's a pilot program that could easily spread statewide, empowering district attorneys to file gun violence restraining orders against citizens backed by vague definitions and zero accountability. So, let's break this down. What AB 1344 really says, what it means for your rights, and why it may be the latest chapter in California's quiet march toward state-sanctioned disarmament. The legal background. How red flag laws really work in California. Before we can dissect AB 1344, we need to understand the legal creature it's expanding, the red flag law, officially known as the Gun Violence Restraining Order, or GVRO. California was one of the first states to adopt a red flag system back in 2016 after a series of high-profile shootings. On paper, the idea sounds reasonable. If someone shows signs of being a danger to themselves or others, the state can temporarily take away their guns. The key word here is temporarily. But here's the legal catch. Temporarily, in California, can mean up to 5 years. And danger doesn't always mean violent behavior. It can be as vague as someone thinking you're unstable, angry, or simply owning body armor. Under current law, a wide range of people can file the GVRO against you, your ex, your roommate, your child's teacher, your employer, even someone you haven't spoken to in 6 months. They just have to walk into a courthouse, file an affidavit, and convince a judge, usually ex parte, meaning without you even being in the room, that you might pose a risk. Once the order is issued, police can show up at your door, confiscate your firearms, and bar you from purchasing new ones. You don't get a trial first. You don't get to present evidence. You find out only when the state knocks on your door and tells you your rights have been paused. Supporters call it common sense gun reform, but as a lawyer, I call it what it really is, a legal shortcut that trades due process for optics. And now, AB 1344 hands that same shortcut to an even more powerful group, district attorneys, the people who prosecute you on behalf of the state.
Breaking down AB 134, what the new law actually does. So what's inside AB 134? The bill Governor Newsom proudly signed on October 10, 2025. In short, it's a massive power expansion disguised as a pilot program. The law creates a 7-year experiment across 4 counties, Alameda, El Dorado, Santa Clara, and Ventura, giving district attorneys the authority to directly file gun violence restraining orders against private citizens. Until now, only law enforcement officers, family members, employers, or educators could file a red flag petition. But AB 134 adds a new player, one with far more institutional muscle. District attorneys aren't just individuals, they're the state's legal weapon. They decide who to charge, when to prosecute, and now, who should lose their guns. The law also establishes a data pipeline between these pilot counties and the UC Davis Firearm Violence Research Center, one of the most politically progressive gun policy institutes in the nation. Every case, every confiscation, every justification must be logged, analyzed, and reported back to Sacramento by 2027, with follow-up evaluations due through 2032. And on paper, it sounds like a harmless academic study. In practice, it's a feedback loop for more confiscation. The center collects data, drafts evidence-based recommendations, and hands lawmakers a roadmap to expand red flag powers statewide. And here's the subtle but crucial shift. Under AB 134, district attorneys can act even when no criminal charge exists. That means you could be under investigation or not under investigation at all and still have a prosecutor file to strip you of your rights. No crime, no indictment, just suspicion. Defenders of the bill claim this is about early intervention and preventing tragedy. But to me, it reads like a due process time bomb. Giving prosecutors the power to punish without prosecution blurs the line between prevention and persecution. If California wanted to test whether liberty can survive under constant supervision, AB 134 is their experiment, and the rest of the country should be watching closely, because once this model proves effective, it won't stay in California for long.
The supporters' argument versus the constitutional reality. Now, to be fair, let's look at the other side of this argument. Supporters of AB 1344 insist this law isn't about confiscation at all. They claim it's about prevention, not punishment. The idea is simple. If a district attorney sees credible evidence that someone poses a risk, maybe a pattern of threats, erratic behavior, or domestic violence reports, they should have the legal authority to act before anyone gets hurt. They argue that prosecutors already handle evidence every day, so why not let them file red flag petitions too? In their view, this closes the response gap, the window of time when police or family might hesitate, but a DA could move fast and stop a tragedy. Even Governor Newsom's office called the bill a proactive, data-driven step towards safer communities. And the UC Davis Firearm Violence Research Center praised it as an evidence-based pilot program that will provide critical insight into how red flag laws function when used by legal professionals instead of civilians. Sounds sensible, right? Here's the problem. Constitutional rights aren't test subjects in policy experiments. Under the 5th and 14th Amendments, every citizen has the right to due process of law, meaning the state cannot deprive you of liberty or property without a fair hearing, the chance to respond, and evidence that meets a defined legal standard. But AB 1344 bypasses that safeguard. It empowers prosecutors to petition the court to seize your firearms before any criminal proceeding even begins. In many cases, these petitions can be filed ex parte, which again means you're not even present to defend yourself. And once your guns are taken, good luck getting them back. Studies of California's existing GVRO system show that most people never recover their firearms, either because they can't afford the legal fees or because the burden of proof effectively flips, forcing the accused to prove their own innocence. That's not due process. That's guilty until proven innocent. And let's be honest, the more successful this program appears, the faster it'll expand. If UC Davis reports that gun confiscations prevent violence, lawmakers will scale it statewide. But they'll never measure the rights they took in the process, or the citizens permanently flagged in state databases without a single conviction. In law, intent doesn't excuse overreach. And when safety becomes the justification for erasing constitutional protections, we're no longer protecting society, we're protecting government power.
Real-world consequences. What's already happening in California. If you think AB 1344 is just another symbolic gesture, think again, because the real-world consequences are already here. California's red flag system has been in place for less than a decade, yet it's already one of the most aggressive in the nation. According to state data and court filings, more than 11,000 gun violence restraining orders have been issued since 2016. That's thousands of people stripped of their rights, many of whom were never charged with a single crime. Take Santa Clara County, for example, one of the 4 pilot counties under AB 1344. In 2024 alone, Santa Clara issued nearly 700 GVROs, more than any other county in the state. That's almost 2 per day, every day, for an entire year. And instead of reviewing whether those cases were justified, District Attorney Jeff Rosen publicly called for even higher numbers, saying his office could do better at encouraging more red flag petitions. Think about that for a second. When prosecutors start talking about boosting their numbers, that's not justice, that's quota-driven confiscation. And the most disturbing part? Under AB 1344, the very same district attorneys pushing for higher counts are now legally empowered to file those orders themselves. It's a self-feeding system. DAs file more petitions, UC Davis reports increased effectiveness, and Sacramento celebrates another gun safety success story. Meanwhile, the individuals caught in this machinery face months, sometimes years of litigation trying to get their property back. Their names go into state databases, their reputations are tainted, their rights are effectively gone. That's not hypothetical. It's happening now. California officials openly admit they're frustrated that red flag laws aren't being used enough. AB 1344 is their answer to that frustration, not by restoring trust in due process, but by giving prosecutors the green light to expand confiscations under the banner of safety. In other words, California isn't just testing this law, it's perfecting the architecture of disarmament. Final analysis: what AB 1344 really means for the Constitution. Let's pull this together and look at the bigger picture. AB 1344 isn't just another California experiment, it's a constitutional stress test, one that asks how much liberty Americans are willing to surrender in exchange for the illusion of safety. Every time a government claims it can predict danger before it happens, it demands more authority and fewer restrictions. The same logic that now allows prosecutors to seize your firearms without a charge could one day justify freezing your assets, restricting your speech, or flagging your political activity. Once risk prevention becomes a legal standard, everything can be a risk, including dissent. From a legal standpoint, AB 1344 flips the burden of proof. Instead of the state having to prove guilt, citizens must prove innocence to recover what was lawfully theirs. That inversion cuts directly against the presumption of innocence, a foundation of both due process and the rule of law itself. And here's where this gets national. California has long been the policy laboratory for progressive gun control. What starts here, from magazine bans to background check expansions, almost always migrates to other states. The data pipeline to UC Davis ensures that success stories from this pilot program will be weaponized as scientific evidence to justify copycat laws across the country. So while AB 1344 might sound local, its implications are federal. It tells other lawmakers you can bypass constitutional safeguards if you frame it as research. That's not just bad policy. That's the slow, bureaucratic corrosion of constitutional rights, one academic paper at a time.
Conclusion. The takeaway. At the end of the day, the question isn't whether we want safer streets. Everyone does. The question is how much freedom we're willing to lose in the pursuit of that safety. AB 1344 gives prosecutors a new lever of power, the ability to disarm citizens before any criminal act. Supporters see that as proactive, but in practice, it's punishment without prosecution, a pre-crime mechanism that blurs the line between justice and control. History teaches a simple truth: rights surrendered in fear are rarely returned in peace. I'm not arguing that red flag laws can't ever serve a purpose. In rare, clearly defined cases, they might save lives, but they must exist within a framework that honors due process, transparency, and limited government, not one that treats citizens as statistical variables in a social experiment. So if you live outside California, don't tune this out. Watch closely, because whatever happens here will almost certainly appear in legislative sessions across the country, maybe in your own state, wrapped in the same comforting language of public safety. Freedom doesn't vanish overnight. It fades through paperwork, hearings, and pilot programs like this one. I'm not your attorney, and nothing here is legal advice, but as someone who believes in the balance between liberty and law, I'll say this: rights only matter when they're inconvenient to protect. If you want me to break down how similar red flag laws are being challenged in courts across the U.S. and what those cases could mean for you, hit that like, subscribe, and comment below. Tell me, is AB 1344 a step towards safety or a step towards state-sanctioned disarmament? And remember, stay informed, stay skeptical, and always think like a lawyer.